Court calls the case to reverse with Richard Young.
Alexander, on behalf of the people, Your Honor.
Defender appearing on behalf of Mr. Young. Approaching, state your name.
Richard Young.
Your Honor.
Yes. Okay, if it's you, Ms. Nendo, okay.
25,000 without the 10%. In this case, the defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV and assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we would be asking that at this time, his bond is set at 25,000 without the 10% into custody, Your Honor.
Response.
Okay, regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through that evidence and possibly at that point we can, address bond again at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
Your Honor, I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, okay, he is, your phone was. Oh, did I give you the iPad? It is my understanding that he is gainfully employed. He is a father. I would ask if he is, he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day.
Mhm.
But he's arraigned on the 4th and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean. So I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those
Okay.
out or I'll send the email to have those released today.
I'm gonna set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the 25,000 yard with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's gonna be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked. So that he'll go into the jail. He won't have phone privileges. Is the court's intention. And then you can get those through with your client and we can figure it out next week. But at this point, defendant's remanded. I'll recall the matter of the People versus Rashad Young.
Alexander, on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
yes, and
Oh, the patience of the court is truly saint-like. Here we have a walking red flag who thinks a restraining order is just a polite suggestion, racking up domestic violence cases like they're loyalty points. And yet, the judge still gives him a chance to explain himself, only to get hit with the classic "wasn't me" defense, even though the jail calls are literally traced to his PIN. Genius. So now, instead of playing phone tag with his victim, he gets a $25,000 cash bond and a well-deserved timeout from his phone privileges, because clearly he treats no contact orders like spam emails, ignores them completely. Maybe a week in silence will help him reflect, but probably not.
Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So if we could get him. Your name?
Tandiana Yates.
All right. Ma'am, I'm gonna let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just gonna let you know, because you don't come into the court that way, ever. Am I clear?
Yes.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let
Ma'am.
you guys know, but he has yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm
Well-
just gonna let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court.
because I feel like it was
I
inaccurate.
will listen to you. I'm not gonna tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information, because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this, because you kind of blurted that out when you had come busting in here.
And my apologies for,
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number, and it was to my sibling. You guys stated on,
If there are
Oh, bless her heart. Barging into court like she's about to drop the hottest legal take of the century, only to get promptly schooled. The judge, with the patience of a kindergarten teacher dealing with a toddler's tantrum, calmly explains that no, the information isn't inaccurate, and no, a dramatic courtroom entrance doesn't rewrite legal records. But sure, let's pretend the court's duty is to personally fact-check with her before making decisions. Maybe next time she can try dialing professionalism instead of chaos before showing up.
References to the case, ma'am, we thought about that.
Okay.
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily, what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I couldn't even be around him.
I am
left.
not going to have a hearing on it right now. I will listen to
Okay,
you.
that's just that was just very inaccurate to me, and I just felt like the way that y'all did that was no. Somebody should have.
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No.
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem. Ms. Cannon, do you want your cases called now? No, I'm good. I am so good, Ms. Cannon. Are your people here? Oh, well.
That's right, they are here. They are ready and they are eager to just listen and learn from this honorable.
The courtroom drama continues, now featuring an impromptu tantrum from the victim. The judge, clearly on a whole different level of patience, listens to the complaints with the grace of a saint, only to have the person keep throwing tantrums like a kid who didn't get their way. But of course, the judge's calm rebuke, while hinting that they've had enough of this circus, is a masterclass in handling chaos. Oh, but wait, we're not done. Just as things seem to settle, the victim tries to reignite the storm, but the judge, as ever, lets them know the conversation is over. Mic drop. It's almost like the judge has a black belt in courtroom diplomacy while the others are stuck at beginner level.